Hello, it's Attorney J again. And um it's usually these type of topics, but I'm Jadina Gustav, also known as Attorney J, and we bid farewell to Aaron Carter, who passed away November 5th, 2022. I come to talk about this because again, we have an individual who has a larger net worth, but it doesn't matter. Like I've said in the past, you do not have to be a millionaire. You do not have to be a celebrity. We're using celebrities as the example because more people know them and it's expected of them. But I believe, and I always say that we all have assets. So if you have an asset, you need to say what is going to happen with it. That's what estate planning is. Passing on wealth, passing on your prized possessions, because it may not always be the financial things, but your prized possessions. So if it's jewelry, it's something that you've created over time, artwork, whatever it is, you have to state what's going to happen with that. Because if you don't, it will have to go through probate. The court is going to determine what is going to happen with that. For example, if you have priceless art that you did not want sold, you did not want an appraisal, you wanted this individual to have it. If you don't create an estate plan and specifically say that, guess what? They are going to list it in your probate as one of your assets. And then the court is going to order that an appraisal be done. The value, it'll either be sold, and if it's sold, the money is split the way that the court said that the money will split it. So again, it is important to make sure that we have the estate plan done to prevent that. So now what's the situation for Aaron Carter? From what we know so far, there was no estate plan in place. He did not have a will or a trust. There was an interview by his manager who saw him only days before. And he said, I believe a month or so before, that they talked about creating a will. They even reached out to individuals to start the process, but it never got done. This is too important to leave behind. So who does he have? We know that he passed away and he was a resident of California. We've discussed California before. In California, their intestate law is going to state who gets it. If he's married, so it's spouse, children, parents, and everyone after. We know that he was not married, so there's no spouse. However, he has his 11-month-old child at the time of his passing. At the time of you're seeing this video, I don't know how old his child will be, but at the time of his passing, his son is 11 months. He only have the one child that we know of. Maybe a parent, his brother, somebody's going to have to file a probate. We've mentioned in the past, one of the expenses with filing a probate is putting up a bond. What we do when we create the estate plans, we make sure that a bond is waived, whether it's will, it's trust, whatever it is, they're not going to avoid that cost. They're not going to avoid this information being public. So whatever he had, whatever is listed, everybody's going to know what he had. Like we've shown in previous videos, we literally show you the court order of what individuals have. So we know that he had a house that was listed for $800,000. That house was taken off the market. They may do another appraisal, and whatever the value of that house is going to have to be listed in the probate. An attorney, they will need an attorney because in California, it's basically $124,000, $25,000. If your estate is above that, you have to have a full probate. And a full probate means you have to have an attorney. It's going to be tens and thousands of dollars that is going to have to be paid to an attorney, which could have been avoided had an estate plan been created. So right now, California states spouse, children, parents. If you have a child, then it all will go to the child. The other thing that is going to happen in this situation, we know that it's, I believe, the paternal grandmother, but one of the grandmothers are the one taking care of the child. However, unless that's legally in place, the mother can step in and become the guardian of whatever money the child gets. Was that something that he wanted? Maybe not, but we don't know because he didn't have an estate plan, he didn't have a will. So everything that he has, it's going to have to go through probate. They're going to determine the value. and it's going to be left to his child. But because his child is still a minor, somebody's going to have to step in to become the guardian, and they're going to be the ones with access to the money. Probably not what he would have wanted. He probably would have wanted to say exactly who was going to take care of his minor's money, how everything would go. But at this point, it wasn't done. So the estate plan is important. Making sure, remember, the will is the bare minimum. A trust gives you privacy. No one knows, no delays in getting what you need. And right now, because it hasn't been filed yet, we don't know the time period that it's going to take, but his estate will have to go through probate, and it will incur fees. That is going to be tens and thousands of dollars that could have been avoided. All right. So like I always say, if you want to get in contact with me, the information is below. You can send messages, put some comments, ask questions, and I'll answer some questions. If you want to talk to me directly, use the contact information so we can have a conversation about this topic or even more. Have a great day.